So thank you so much, Danny. All hats off to you for organising this. James, such a pleasure always working with you. It is an absolute honour and privilege to be here talking with all of you today. And I'd like to say a special thank you and welcome to lots of teams and individuals that I know are live streaming, and hello especially to Sawbridgeworth. You know who you are. So we've got a great team monitoring the chat. Danny, I don't know if I'll have time for questions, but I'll be outside and hanging around. And I'm also more than happy to be contacted on social media. I'm very visible on social media, so if I don't answer your question today, and judging Celia by your session, there's going to be lots of questions. I'm more than happy to be contacted afterwards. So I'm going to be talking about lasting power of attorney and what every healthcare professional needs to know. I know we've got lots of members of the public here today as well, but don't be put off by the title, because this session is for all of us. Danny, you've mentioned that word mortals before. This session is for you. Put your hands up. If you are a mortal, you are in the right session. Okay? Right, most of us here. Bingo. If you're not putting your hand up, I want to meet you in the break. So before I start my presentation, I want to tell you a little bit about the why. Why do I do what I do, and why do I care so passionately about it? So I started training, I'm going to share my secrets now. I started training in 1987, before lots of you, I think, were born. In that time, I wore a paper hat. I had to learn how to fold a paper hat before I started training. Can you believe that? And just before I qualified at Guy's, I didn't get the chance to wear. Does anyone remember those lacy hats? Yeah? I didn't quite get the chance to wear a lacy hat. They took those out just before I qualified. I earned £246 a month. Okay, that was a while ago. When I was training, the Enduring Powers of Attorney Act had come in a couple of years before in 1985. And that was designed to allow individuals to appoint somebody to manage their financial affairs and their property if they ever lost capacity to do it themselves. When I was training, I don't remember anybody even mentioning the word enduring powers of attorney when I was training or even after I qualified. The Mental Capacity Act, 2005, laid the groundwork for lasting powers of attorney, and it came into law in 2007. I'm looking for Celia here to make sure I'm getting my facts absolutely right. Where are you?
Yes, you are.
Thank you. Phew. Now, I attended Mental Capacity Act training. I'm guess, stick your hands up. Anybody here attends mandatory Mental Capacity Act training? We do it every year. Tick, 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 tick. I have attended MCA training from that point onwards in roles for acute trusts, for the community, for hospices. I've been a CQC Specialist Advisor. I've worked for GSF. During that time, was I ever taught about lasting power of attorney? Yes or no? No. The picture in 2016 is my leaving do at an acute hospital. Now, I vividly, like all of you in this room, we carry our patients, don't we? We remember those stories. Christian, you spoke about those stories that have influenced your patients, that have influenced your practice. I vividly remember the people I was caring for. I remember the conversations that I had with families. I remember the conversations. We were going to make a lasting power of attorney. How many of you have heard that? We got the forms to make a lasting power of attorney. My husband meant to make a lasting power of attorney. Had they done it? No. Again, did we have discussions as healthcare professionals? Were we taught, did I have perhaps the education, I'll put my hands up a minute, did I have the knowledge and education that I needed to properly care and advise my patients? And I'm not ashamed to say that I didn't. So despite how important these forms are and were and are for all of the people you are caring for, we have a responsibility to understand. We have a responsibility as healthcare professionals to understand this in more detail, I would argue, than we currently do. From 2018, I've nearly got to the end of my story. I've got 30 years to condense. I'm sorry. I'm trying to do it as briefly as I can. From 2018 to 2021, I was end-of-life care lead at a really large community setting. I was implementing advanced care planning policy, supporting policy development and clinical care. And again, boring question now, but did my training, my tick box MCA training at this point, did it teach me any more about this really important thing called lasting power of attorney? It's a trick question, you guessed it. No, it didn't. So that leads me to 2021. So I founded Speak For Me in 2021, achieving a really long ambition to support professional education and raise public awareness about planning ahead and to normalise these conversations. Danny, it's very much what we're doing here today, is normalising these important conversations. I also knew that I could provide what I hope is a very human face to lasting powers of attorney, and I became a lasting powers of attorney consultant as well. Now my throat's, sorry, I shouldn't keep doing that. My throat's gone a little dry because this is the first time I've included this bit in a presentation, but in 2022, clinical practice for me became a family reality when my dad, my incredible dad, had a stroke. So having lasting powers of attorney in place made the most traumatic of situations for us as a family just a little bit easier, because I knew that as a family we could advocate for my dad when he didn't have a voice. I'll also tell you that anybody who wants to meet with me on a Friday now, you can't, because that's the day that I still take my dad out for lunch every Friday. So there's a great ending to that. So I want each and every one of you sitting here today and listening online to know the things that I wished I'd known as a healthcare professional during this timeline. That's why I'm here today. So I'll be talking as quickly as I can about what a lasting power of attorney is, how it aligns to advanced care planning, what we need to know, healthcare professional or mere mortal, and I'll close with a challenge to you. So I've shared my professional story. I started the presentation with my professional story. I'd like to now describe, before I describe the nuts and bolts of lasting power of attorney, I want to share some recent feedback that I've received. It's a professional story now. So I always find it an absolute honour and a privilege working with families and being part of the conversations behind the forms. These forms mean nothing without the conversations. So I created this lasting powers of attorney for a couple, working with them and their daughter to draft the documents. And we spoke about what matters most to them. And I can't see Zoe in the audience, but we also used the My Future Care handbook, thank you Zoe, to document the rest of their wishes. So these things go side by side. They support and complement each other. So I was recently informed of the death of the husband, and I was humbled to receive this email. So I'd like to take this opportunity to thank you once again for your help in setting up Mum and Dad's LPAs. Not only did this bring peace of mind that we would be in a position to support Dad when the need arose, but it also necessitated all the important conversations about end-of-life wishes, leading to a greater understanding and preparedness when the time came around. So this feels so incredibly powerful to me, and it gets to the absolute essence that having a lasting power of attorney can make and the conversations that it can start. So, okay, nuts and bolts time as quick as I can. I'm not going to focus on this section too much. You can go onto the Advanced Care Plan Day website. James, you've done an incredible job with that website, and people can still access the conference from last year. So I spoke in quite some detail then about lasting powers of attorney. But I just want to set the groundwork so that we're all on basically the same page throughout this presentation. It's also really important now to say that I'm talking about the law as it stands in England and Wales specifically. We heard from Christian and different cultures this morning about the family role in different countries, and in our panel discussion this afternoon, we'll hopefully be exploring legislation across our UK nations. So what is a lasting power of attorney? A lasting power of attorney is a legal document that enables an individual over the age of 18 and with capacity to nominate a person or people to support them to make decisions or make decisions in their behalf if they lose capacity. Now remember the multitude of ways that capacity can be lost. The poor Dartford Bridge gets a very bad bashing whenever I do this talk, because I always say I could lose capacity having a car accident when I drove up here today. I don't know why I pick on the Dartford Bridge every time, but I just do. So capacity can be lost in a sudden accident, a car accident. How many of us drove here today? Not wishing to be miserable, but think about it. Capacity can be lost through a sudden sporting injury, that's sudden head injury, as well as the longer-term health conditions that we think of, the dementia, the Alzheimer's. Staying with capacity, it's important to remember that capacity is time and decision specific. It needs to be appropriate to that decision being made. We need to understand the Mental Capacity Act. There are two different types of lasting power of attorney, one for health and welfare, one for property and finance. And you can choose with the property and finance LPA for that to become effective as soon as it's registered. It's important that you guys know that if you're talking about options with people. If, for example, somebody has a broken hip, they may be in hospital, they may have the mental capacity to do their banking duties, but they can't get to the bank. In that case, that's a great example of saying that their attorneys can use that lasting power of attorney as soon as it is registered. I mentioned EPAs in the first slide I had, enduring powers of attorney. Just be aware that before lasting powers of attorney, when we had EPAs, you could only confer powers, I think I already mentioned, for property and finance. If you come across somebody with an existing EPA now, whilst they can't be created anymore, EPAs that have already been written are still valid. So let's very, very briefly glance at the law that lasting powers of attorney are built on. Celia, you spoke in, I keep losing you. Pop your hand up, Celia, because I'm going to keep referring to you. Thank you. You spoke in detail about the Mental Capacity Act, and I've just put a brief slide up here just to highlight the importance of the Mental Capacity Act. You'll see here in the slide I put up reference to the Mental Capacity Act. Why have I put this here? I'm showing you this slide just to remind all of us that the Mental Capacity Act is so very important. Yes, I'd argue it does need updating at some times. There is work going through. But learning more, if we learn more about the Mental Capacity Act, it will enable you to answer questions to your family and to your patients about understanding a lasting power of attorney. So moving to my second name, how does lasting power of attorney align with advanced care planning? It gives me shivers presenting this slide to you. See Danny smiling here. I created this infographic because so many healthcare professionals and members of the public we just didn't get advanced care planning. In all the health settings I'd worked, I did the same thing again and again, and that's teach what advanced care planning is. If we had time, it would be great to do a poll on all of us, just to write down, what do you think advanced care planning is? What does it mean in your area? And I'd guarantee out of 300 people, we'd get 300 slightly different answers. But for me, I don't care where you are, what stage in your illness journey you are, what health authority you work in or country, it's built on these principles. It's built on the foundation of what matters most to you. We think about the things you do want, potentially expressed in a statement of wishes and preferences, the things you don't want, Celia's discussion about ADRTs, who would speak for you, your legacy. James, you did a fantastic session for us last year on digital legacy, often overlooked. And that small window as well is, end-of-life care is sometimes to do specifically with end-of-life. Advanced care planning, excuse me, is specifically sometimes aligned to end-of-life care. So thinking about treatment escalation forms, potentially, thinking about medications. Obviously, the session I'm doing is who would speak for you. So it helps to see how it aligns and fits in to advanced care planning. So having set the scene, explained what LPAs are, and put them in the context of advanced care planning, I'm now going to jump on to what I think you need to know. And to do that, I'm going to break lasting powers of attorney down into 3 touch points that you may have interactions with your patients or people you care for and love with. And that's before, during, and after. So starting with before, and I'm going to be thinking about awareness, time, cost, and the important communication. So let's start with awareness. Any of you that have been to my sessions in the past know the answer to this, so you've got a heads up. How many people, what percentage of the population think that next of kin always get the final say in treatment decisions if the person can't make them for themselves? Go on.
Yes, of course.
Next of kin is somebody that I will ring at 3 o'clock in the morning to give them some news. The next of kin does not have legal authority to make decisions on behalf of somebody else. However, how many of us think that? Around about 72% of people. I know that's quite old data now. I think it'd be great if that was redone, but the last time I looked, it's around about 72% of people think that next of kin get final say in treatment decisions if you can't make them yourself. That is incorrect. I would argue it's probably one of the biggest myths that we can debunk. Danny, I can see you nodding down there. I can see lots of nods in the audience as well. Now, lots of people say to me, well, I don't need a lasting power of attorney because I talk to the doctors already. I phone up the GP and the GP gives me mum's test results because mum said I can. Why? How does that work? I don't need a lasting power of attorney. It's a waste of time and money. The reason it works in that circumstance is because mum has given consent, aligned to the Mental Capacity Act. She has consented to allow the daughter to access those medical records. But as soon as capacity has been lost, she can no longer continue to consent. So it's a little bit like consenting in advance with who can have that information and share that information for you. The word choice is on the slide there. It's a good point for me to say that an attorney, it's a really important point, can refuse treatment on behalf of somebody, and they can consent to treatment on the behalf of somebody. But what they cannot do, they cannot get that lasting power of attorney form and say, you must do that treatment to my mother because I'm the attorney. You cannot demand treatment as an attorney. And I know I've been in that position of people, very distressed people, saying to me, please do that to me, and I'm going to make you do that to me because I'm the attorney and I'm telling you you must. An attorney can't do that, but think about that, and it makes sense. Because none of us in this room can go to a doctor and demand inappropriate treatment now, can we? So we can't do it in our role as an attorney. An attorney must always act in somebody's best interest. Celia, you've spoken a lot about that in the earlier slide. It's not a benign for the best. There. Best interest is laid down in the Capacity Act, taking into account the wishes, values and beliefs of a person. I haven't got a slide this session for property and finance, but it's worth knowing that another really common myth that we need to debunk is people think that if you've got a joint bank account, you don't need a lasting power of attorney. Because if somebody loses capacity, hey, it doesn't matter. You've got a joint bank account. Around about 73% of people believe that. However, if one of the couple are to lose capacity, the other person cannot continue to legally manage that joint account for them both. How many people think that's 73%? So a huge, huge myth that we have a responsibility to debunk as healthcare professionals and as daughters, sons, mums, wives, fathers, mothers, you name it. So I don't know about you guys, but simply being armed with that information changed my understanding of lasting powers of attorney. They are not, for me, an optional extra. They are critical to me to know that the people I trust the most can make the decisions that matter the most to me. So by now, I hope you'll agree that having a lasting power of attorney is important, but how many of us have got a lasting power of attorney? If you're comfortable to pop your hand up if you've got a lasting power of attorney for health and welfare. Now, my maths is shady at the best of times. Standing nervously behind a lectern, it's even more shady. But even I can see that's not a lot. So statistically, my statistical analysis of this room is not a lot. Research tells us around about 7%. That's right, just 7% of us. And looking at the room, I would say it's probably less than 7%. It would be good perhaps to do a poll one day of this room. And bear in mind, guys, we are the converted. We have come here because we are aware of advanced care planning, so we're a good crew. Think about it for a moment. So if we're not doing it, we need to start thinking about it for ourselves as well as our patients. So yeah, 7% of us have got a lasting power of attorney, hopefully a few more by the end of today. Danny! Oh, that's the goal for next year. Where are you? I'm watching you. You're next. You shouldn't have admitted that because before too long you're going to be on that stage. This time next year you're going to be up on this stage. So staying with awareness, and it brings me to my second point, a Which survey found that around about 77% of the population, 77% of us think that we can set up a lasting power of attorney whenever we need it. But think about it. You have to have capacity to set up a lasting power of attorney. You set that up for a point in time that you don't have capacity. So how can you set it up when you need it? You can't. It's bonkers. But around about 77% of us think that that's true. So it is shocking. These statistics are shocking. We have got a lot of work to do to debunk these myths. Our next myth to debunk, or thing to be aware of, is how long it takes to do a lasting power of attorney. Pre-COVID, it was around about 8 weeks. That's if there's no problems on the forms or the applications. During COVID time, they were typically coming in around about 20 plus weeks. I'm finding they're now coming back around about 15 weeks. If you look on the Office of the Public Guardian website, it says 12 weeks. I think if we allow ourselves 15 weeks is appropriate. But again, stop and think, how long is 15 weeks? When my dad had his stroke, I cannot begin to imagine the agony of waiting. We couldn't have done it, we'd lost the opportunity. But you imagine being in a crisis, needing that form. 15 weeks is not a go. And it will go through waiting, received, checking, and processed. Something else to be aware of is cost. I spoke to somebody today and found out, and I can't see you in the audience, but they told me somebody had been quoted nearly £1,500, I think, to do 2 lasting powers of attorney. So cost can put people off. That's the cost of a solicitor. However, it costs, if you do it yourself, just £82 to register a lasting power of attorney. So each lasting power of attorney must be registered with the Office of the Public Guardian, and that will cost you £82. But the good news is, there is the availability of exemptions and remissions. How many people know that? So if somebody is put off doing a lasting power of attorney, and if their income is below £12,000 per annum, and that could be an income or a pension, the application goes down to just £41, Danny, just £41 per LPA. Out of interest, it's the only government thing that I know has come down. It used to be 120p for those LPAs, it's now down to 82, so get in there before they put it up again. Now, for some people I work with, typically people who are on pension credit, the cost of registering a lasting power of attorney goes down to 0, absolutely 0. So as long as you can prove somebody's on pension credit, and it's typically that gov.uk letter that they'll get annually, you can fill that in, and the lasting power of attorney will be free to register. I think that's really powerful knowledge to be armed with. So I'd like to ask you don't need to put a show of hands, but just take a moment to think, how many of you in this room were aware of exemptions and remissions? And how many of you have got that information available for the people that you look after as they're coming to your clinics? You put your hand down, Celia, you're not included. So yeah. Don't be telling people off mid-session. So I've looked at awareness, time and cost, but perhaps most importantly is communication. How do you have those conversations with those that you love? Well, align it with advanced care planning. Put it in as part of general advanced care planning, using that house example. Understand it's a process, it's not just a one-off event. And for me, it's very much about gaining control, not losing control. I'm sure it will resonate with lots of you. I work with so many people that say, Dad won't do a lasting power of attorney because he is frightened of losing control. Okay? But remember, a lasting power of attorney enables you to nominate who you want to support you to make decisions or make decisions in your best interests. I'd rather have that than a court-appointed deputy making decisions for me. Staying with communication, debunk the myths, all the things that we've been talking about today. Next time you're having a cup of tea, I know it's not an exciting conversation, but here, did you know that joint bank account we've got? Well, it's going to be no good if. Okay, so debunk myths. Current media is fantastic. Now, I'm not ashamed to say, on Boxing Day, my daughter told me to watch EastEnders, and I've been slightly rehooked ever since. Slightly awkward, but there we go. But there is a fantastic storyline there. Anybody following the storyline of Nigel with his young onset dementia? Please, at least one person put your hand up and admit to watching EastEnders. Thank you. So in EastEnders, Nigel has been diagnosed with young onset dementia, and the big and burly Phil is trying to be his carer and help for him. And I'm shouting at the television, come on BBC, this is your opportunity to write a script, because Nigel needs to be doing that lasting power of attorney now, because I'm looking at a Nigel thinking he hasn't got much longer to do that. So using media can be a great way to start conversations with the people you know and the people you love. Lots of you have seen information on the waiting room revolution and the 7 keys to navigating a life-changing illness. And there are trigger points. Diagnosis of a life-changing illness is a trigger point. How many of you meet patients in your clinics? And having reviews, these are all trigger points that you can have these conversations about lasting power of attorney. So how do you do a lasting power of attorney? There are 3 ways. I've moved on to the during phase, so I'm going galloping at speed here. How do you do a lasting power of attorney? You can do it yourself. I've mentioned that and the costs already. You can go to a solicitor, or you can come to me. I work all over the country. Obviously not just me, but a lasting power of attorney consultant. And I do work with people all over England to do that. Obviously, there's pros and cons to each of them. I've written lots of blogs about this, and for the sake of time, I won't go into all the details now, but do your homework. Find out which option is best for you, because for different people, different choices, there are pros and cons to them all. So moving on now, may I please have Mr. James Norris from the audience? So, first of all, I need to say a huge thank you to James for sharing something so personal on stage. And we are going to are going to help James do his lasting power of attorney, if that's okay with you. Yeah. Would you like a chair? Oh my gosh, that's heavy. Nobody told me that was heavy. You said you can go and get the stool. You didn't tell me how much it weighed. Okay. So what we're doing today is James's lasting power of attorney. So what have we done in the lead up to this? James and I have had lots of conversations. We've spoken about your wishes and we've spoken about your options. Was anything surprising? I don't know if are you able to talk?
I'm not sure if the mic's on. Excellent. Yeah, so a few things were surprising. So to start off with, I knew that I should have completed my LPA. It's something that has been on my bucket list for a long time, but circumstances has just made me kind of put it off and put it off and put it off. Probably the thing that surprised me the most was I could have both of my brothers as my lasting power of attorneys. I didn't want to pick one over the other and one be a favourite and one not be, and they're both as sensible as one another. So I thought, you know, it'd be great to have both of them, and I didn't know that was possible until we had our conversations.
And I would argue that's one of the advantages of talking it through. So these forms you need your choices and your options spoken through. So what I'd like to demonstrate is the role of certificate provider. So I answer lots of questions through my work every single month. And the question I got this month was, can I be a certificate provider as a friend, or do I need to go to my GP or a solicitor to do this function? And I'm really proud, James, to be doing this as your friend. So I have known you for over 2 years. I believe you're not being coerced into this, apart from me, who said you've got to do this on stage today. But apart from that coercion, sorry, if that goes down in the court of protection, I'm sure that's not a coercion, is it?
Celia will be there at court.
So I'm not coercing him. I'm not. So I believe you've got appropriate capacity. I believe because of the conversations that we've had, you understand what you're doing. We've had discussions about when your lasting power of attorney will take effect, and we've signed page 10 already. So I'm simply going to be signing page 11 of your lasting power of attorney and acting as your certificate provider. And James, thank you for asking me to do that. It is my tremendous pleasure. No, so my I'm doing it live for everybody now. And what's today's date?
It's the 7th.
07/05/2025.
You can just write Advanced Care Plan Day 2025 instead.
Do you think the Office of the Public Guardian would be all right with that? Okay, I'm sure they'll be fine with that. So I'm going to give these to James. James knows you've got the signed instructions. You know what's you're going to do next, and then you're going to send back to me, and I'll send off to the Office of the Public Guardian for formal registration, and we'll update you guys next year with the results. So Excellent. Thank you for doing that.
Thank you so much.
So, big rounds to James for doing his lasting power of attorney. Thank you. So that's how you do a lasting power of attorney. You haven't got to do it at a conference, by the way. I'll let you get away with it at home in the privacy. So I've looked at before, I've looked at during, I've done it on stage for you guys. I'm now going to briefly move us to the after stage. I'll be looking at checking, emergency access, advanced decisions to refuse treatment, and I'm going to close with the experiences I had in the Open Justice Court of Protection project. So checking. I think this is so important to know as healthcare professionals. How many of you have just been given a letter to say, I'm lasting power of attorney? I can see somebody nodding there. Because here is the letter that I've got from the Office of the Public Guardian. The letter is not the document you need. You need to see the original document, and I've got a slide for that. Next slide. Or you can access it digitally, and I'll explain that as well. You need to clarify which lasting power of attorney document you are talking about. So it's no good if you're looking after somebody and you're thinking about their health and welfare wishes if the document is a lasting power of attorney for property and finance, so clarify. If it is an LPA for health and welfare, has option A or option B been ticked? How many of you know there's an option A and an option B on a lasting power of attorney form. Thank you. There's one hand up. Option A, 2 hands up. Option 3 hands up. Lord be praised. Option A enables your attorney to make what's called life-sustaining treatment decisions for you. So important for us to know that. Has the LPA been registered or simply applied for? How can the attorneys act? James, thank you very much. You've told us already, so I'm not breaking confidence. You've got more than one attorney. So as a healthcare professional, we need to know, of those attorneys, are they acting jointly? Are they acting jointly and severally? Or are they acting jointly for some decisions and severally for others? Because if you've got somebody whose attorneys are acting jointly, you need to hear the voices of all of those attorneys. So it's simply not it's not simply a piece of paper. We need to understand the those nuances of a lasting power of attorney. Excuse me. Again, are there any special preferences or instructions written on the form? So there is a free text area on the form that we can document instructions and preferences. Be very, very careful here. Be very, very careful. And I often recommend that people do something like the My Future Care Wishes or an advanced statement of wishes and preferences that can be updated and changed. So always ask to see the original document, that's for LPAs pre the 1st of January 2016. So the picture on this slide shows you what a lasting power of attorney document looks like. You can see that red circle at the bottom. That's where you'll see perforations from the Office of the Public Guardian. So LPAs post-2016 can be viewed electronically. If I had £1 for everybody that said, Claire, how do I access this online? I won't see you next year because I'll be in Bali. But I don't charge for this information. So you can access, you can view, you can share, view and access lasting power of attorney digitally, but this seems very, very unknown information. See, I don't know if you have this question a lot, but so few people seem to be aware that you've got this digital access, and that includes healthcare trusts, that includes banks. How do you do that? You have to use the gov.uk user lasting power of attorney service. You'll have an activation key as a donor. You're creating that lasting power of attorney, and the letter of registration will contain your activation key and your reference number. James, when we come back next year, you can perhaps talk people through how you saw and accessed your lasting power of attorney online. Because I get asked about this so often, the editor, Martin, the delightful chap who works with me and edits my podcasts, he's created a video, a YouTube video, that is literally a step-by-step guide. So, Danny, are the slides available for everybody afterwards? So I've put links to all the things that I'm talking about, and you've got links to a guide to walk you through how you access a lasting power of attorney digitally. And I challenge you all to think, can you make that available to the people and patients, the people you work with, and the people you care for as well? So I've written seven separate blogs. I told you I got asked it more than anything else, but I've written 7 separate blogs all about how to access a lasting power of attorney online. Briefly, if you're in a position that you need to know very, very quickly, I need to find out, my patients in hospital, have they got a lasting power of attorney? There's a template here in front of you. I won't read it verbatim, but there is a specific template that you can send. I understand there are 5 working days is the timeline for that to come back to you to find out if somebody has got their lasting power of attorney. You can also apply online. It takes longer. Which one takes priority? I love this slide. A lasting power of attorney or an advanced decision to refuse treatment? Look, show of hands, does the lasting power of attorney take priority? Does an advanced decision to refuse treatment take priority? So hands up went for both. And I want to say thank you for everybody brave enough to put your hand up, because I know it's horribly scary. But quite simply, the most recent document takes priority. So if you have created an ADRT, Celia's looking at me aghast here, but my understanding, I'm being challenged live on stage here, this isn't scary at all, folks. My understanding, I'm moderately confident, is the most recent document takes priority. So if an ADRT has been written after a lasting powers of attorney, the ADRT will be effective. If the ADRT has been created before the lasting powers of attorney, and then an LPA is created, Celia's going to challenge me. I'm going to be rugby tackled on stage. It's the most recent document.
Okay, first of all, it's not the most recent document you wrote, it's the registration.
Signed and registered.
Registration. So,
Yes, yes.
So you would need to wait for the LPA to be registered and then do your advanced decision afterwards. But many people who already have an advanced decision to refuse treatment can nonetheless subsequently do an advanced LPA without rewriting
Yes.
their... Yes?
Agreed.
How would you do that?
So I would get people to...
You would get people to...
So if people have got an advanced decision to refuse treatment and then do their lasting powers of attorney, I would encourage people to redo after as well, their ADRT.
Okay, so some people can't do that because they don't have time.
So what do they do?
Or they've lost... Okay, so they fill in
I'm going to
on-
rugby tackle in a minute.
No, this is good.
Go on.
What they do is you fill in on the form that you are not granting to your attorney the right to make any decisions that you've already made for yourself in your advanced decision to refuse treatment. The crucial thing is just that doctors need to know who makes the treatment decision. So
Perfect.
for any one treatment, is it that you've already made it in your
Yeah,
advanced decision, or is it the attorney's? So you just put it on the form.
Thank you. And this is on video, so that learning can stay on video, so thank you.
Thank you.
Thank you. So I'm going to do a really quick whiz through an Open Justice Court of Protection case. Now, I should have said earlier, Celia, you didn't big up the OJCOP project as much as you should have done. I have learned more about Celia's more about the Mental Capacity Act and lasting powers of attorney, although clearly not enough as I should know, through attending the Open Justice Court of Protection blogs. And I'd encourage project hearings. I'd encourage anybody here to do so because it's a great way of your professional development. You can go to a hearing, you can blog about it with great support from the team, fantastic support, and you learn so much and use it as part of your revalidation. So I'm going to draw on the experiences of the Court of Protection, Open Justice Court of Protection project and a hearing that I wrote about. There were 3 blogs written about 2 hearings for Mrs. W. 2 were interestingly written, Celia, by yourself and your sister Jenny, and one of them was by me. So excuse me, I'm going to read this out. This might be a bit wooden, but I want to get my facts straight. So Mrs. W was a woman in her late 70s, and she had a brain injury. A nasogastric tube, NGT, was inserted in or around the 23rd of October 2023, removed round about 4 weeks later. And this was opposed by her son and daughter. Now, according to the Mental Capacity Act, we've looked at that already. The views of the son and daughter should have been taken into account about what Mrs. W would have wanted and what is in her best interests. On November the 12th, the son and daughter emailed the trust stating their objections. They were advised there would be a second opinion, but this did not happen. They reiterated their concerns on November the 15th, advised then the NGT wouldn't be reinserted. They were later told of a DNA CPR as well. On a meeting on December the 7th, no agreement was reached, and hydration has also been withdrawn at this time as well. So the son and daughter in this case, and I'm quoting from the blogs, were not simply next of kins. They were Mrs. W's attorneys. They had option A. We've spoken about option A. They had that option, and there was no suspicion that the lasting power of attorney hadn't been correctly drafted and, really importantly, registered as well, way back in January 2020. It was up to the attorneys to make decisions in Mrs. W's best interests, whether or not life-sustaining treatments that clinicians were willing to offer, willing to make available, were consented to or refused. The Trust issued a sincere apologies because the attorneys were not consulted, and they also apologised for not consulting the Court of Protection earlier. It was unclear. We don't know if the treatment was or wasn't clinically indicated, but certainly clinically assisted nutrition and hydration guidelines were not followed in this case. Sadly, Mrs. W died the night before the second hearing, and it was really unusual. I don't know, I've attended so few hearings, Celia's attended a lot, but hearings don't usually go ahead if somebody has died. But it did in this case for lessons learned. It was so important. What can we learn? So reflecting on this, by not consulting with Mrs. W's attorneys, the Trust failed to recognise their legal role. The lack of communication was also highlighted as a failing for which the Trust has apologised. Witnessing the hearing, I wrote, it appeared that the failing to consult with the attorneys was not the result of a single person, rather a systematic failure. And there is little point in people making lasting powers of attorney if they have no traction at all. And there was no mention of lasting powers at all, powers of attorney in the doctor's statement, and that was by Katie Collop, the QC at the time. So what can we take away? What can we take away from what I've spoken about this morning? Check your trust policy. Go away tomorrow and check your trust policy. Review your admission process. How and when do you ask about lasting power of attorney? And have you simply got a tick box that has got lasting power of attorney, or can you explore more? How many are there and who can act for that person? Discuss, this is probably my biggest plea to you, discuss lasting power of attorney at key trigger points, at a diagnosis, at follow-up, at your appointments, on admission, on discharge. Know how and when to signpost patients to. Members of the public, ask your local library, look in your local chemist. Is there information available? If not, ask. And provide lasting powers of attorney education for all of us. Everybody here today, go and provide education. So I said I'd close with a challenge, and I'd like to ask each and every one of you here today, who would make decisions for you if you could not make them yourself? I encourage you all to make a pledge. Thank you for listening.